this law by the state of New York was only passed as a knee-jerk FU middle finger to Bruin. It is exactly, I think, as anticipated. We are the Armed Attorneys. Today we're talking about the latest Second Amendment win coming out of the state of New York. We're going to talk about what case this was, where it's going to go from here, because it's not over, and did the anti-gunners gambit backfire and fail, or did it go exactly the way they wanted? But before we get started, show your support for the Second Amendment by hitting the like button.
And we're in election season, so YouTube's monkeying around with stuff. Make sure you are subscribed. Check your subscription status, because we've seen and heard from a lot of folks who have said, hey, I don't see your videos anymore.
Hit the bell, even though you're probably not going to get notified anyway.
Exactly right. But all right, so what do we have here? Well, in response to New York State Rifle and Pistol Association v. Bruin, that was in 2022, we saw a lot of states make lots of reactions to it. And instead of saying, you know what, we learned our lesson, we shouldn't infringe on the Second Amendment anymore, they stepped on the gas.
Yeah, instead of being like, you know what, I don't care for this law that's come out of the Supreme Court, but I will respect it. As a lawmaker and as someone who has sworn an oath to uphold the Constitution, I will in fact do that.
Yeah.
No.
I've done a lot of self-reflection, and I've decided that what I did was totally awesome.
Yeah.
I mean, that's basically what happened. And so we have New York here. In response to that, they said, hey, guess what? We are going to make this incredible maze of gun laws that make life for the average gun owner an absolute hell on earth. And one of the provisions was this presumptive carry ban. And essentially what it did was it created this default by which private property owners, it was presumed that carrying on private property was banned unless the private property owner affirmatively gave notice that, hey, guess what? Carrying in this location is permitted. And so for a little while, we had a lot of silly signs going around New York because everybody was posting signs saying, hey, you can carry here.
It's okay to carry.
But it just left a lot of people confused.
Yeah. And here, just sidebar, you can really tell a lot about governmental priorities by how many hoops they make you jump through to get a certain thing. So to give you an example, Texas, the exact opposite, right? We have in the state of Texas, presumptively, you are allowed to carry into private property unless given notice otherwise. And the notice has to be ridiculously explicit. It has to be directly statutory language, 1-inch block letters, contrasting colors in English and Spanish, so on and so forth. And the government does not produce these signs and give them to you. You have to go into the statute, find the language, produce your own sign, translate it into Spanish yourself, and then post it. So they make you jump through 1,000 hoops in order to tell people who have licenses in Texas, you can't carry in here. Whereas New York is the exact opposite.
Yeah.
Which is crazy.
Fun fact, our office produced the Spanish translation of the 30-05 sign for firearms.
That is true.
And I don't know that it actually makes sense. So if you're a Spanish speaker, go check that out. Texas Penal Code 30-05. But all right, so we have, and then even Texas goes even further. We say, hey, the fact that a private property owner does not exclude firearms cannot be raised for any reason in a trial for civil liability. And so, I mean, we go a step further and even protect private property owners.
Oh, and you remember in 2019 when we said, like really sneakily, that if you don't get oral notice, you have a defense to prosecution for violating the signs anyway. So the signs are basically meaningless in Texas if you're a license holder. Don't tell anyone.
All right. All right. That was a fun.
Good aside.
Good
All
aside.
Right.
Back
Moving on.
Off sidebar. But all right. So what do we have here? We have the Firearms Policy Coalition, along with some other plaintiffs, suing the state of New York, seeking to render this statute unconstitutional. And what do we got?
So we have a preliminary injunction granted in 2022, very shortly after this law was passed, which is great. So I think one anti-gun goal when they pass a law that is blatantly unconstitutional would be just mess with people until the court sorted out anyway. And they didn't get that here.
No.
Right? Because we had our injunction granted. We had the Second Circuit of all circuits saying, you're right. They affirmed the injunction. And now we have these cross motions for summary judgment. Plaintiffs, which is FPC and an individual named plaintiff, and the defendants, the state of New York, And we have these cross motions, and finally the case has been finally decided. They have granted summary judgment in favor of FPC and plaintiffs, in a good Bruin analysis. I mean, there's just no other way to, y'all are going to get bored, every time we're like, well, the Bruin, the Bruin, the Bruin. It's just a good, solid Bruin analysis.
Yeah, so we look at the text of the Second Amendment. Hey, is this conduct regulated? Does this implicate that? Guess what? Carrying in public? Absolutely. The law is presumptively unconstitutional. And then we look, hey, is this something that the founders would have, founding era, think, state legislatures, is this something that they would have regulated as we know that term to meaning today? Is that something that they would have regulated? And guess what? This whole burden shifting, this presumptive, you can't carry, there's just nothing to support that in the law in 1791.
Afraid. That's the only thing they ever say. No,
Yeah.
You're right. There's nothing. There's nothing to support it. So it's good. Bruin functioned as contemplated. However, this law by the state of New York was only passed as a knee-jerk FU middle finger to Bruin. It is exactly, I think, as anticipated. And even though New York lost and they got slapped down, this is, I think, an interesting question. Did New York get exactly what it wanted anyway?
Yeah, I mean, we're going to talk about winners and losers here.
Did it backfire? Did this law backfire, I guess, is the question.
Yeah, ultimately, the law backfired.
Did it, though? Because they
the
knew.
law, we have instruction. All right, we'll go back and forth. You do your thing first.
Thank you. They knew. They knew they were going to lose. So I think when they passed this law, I mean, maybe they thought that the injunction would not be granted and they would get to violate people's rights for several years until it played out. But even though they didn't get to do that, what they did get to do is drain FPC's coffers.
Yeah, I think...
Which is a goal. It's a big goal for them.
I think the argument for, hey, this did backfire is, well, and this is one of the most frustrating parts of litigating Second Amendment cases. We all, and I think we've said it before, when we had New York State Rifle and Pistol Association, I think there was this air of there's no such thing as a constitutional gun law anymore, which, I mean, I largely agree with. Mm-hmm. And so we have, all right, this going on in the air in the background. Well, that case was just about the legal framework by which we judge infringements, and it didn't actually address any of the infringements.
Right.
Who can carry, what we can carry, where we can carry, how firearms are sold. It didn't really touch any of the things that we actually care about. And so the question of, hey, can the government generally prohibit carry in public? This is a slight twist on it. This is this presumption that exists with private property owners. All of these little details getting sorted out, I think it's still very important. So even though I do think that there are some lawmakers who in their heart of hearts thought this is a great law, this is going to make people more safe, even though that's all BS, but we got an answer to a question that we hadn't asked before, and I think it has implications. Think about what happened in New Mexico with the governor saying, hey, we're going to declare all these public places sensitive areas.
Mm-hmm.
We have some language in this case that I'm not a huge fan of where they talk about, hey, this wasn't narrowly tailored enough, which sounds a lot more like a strict scrutiny test as opposed to New York State Rifle and Pistol Association.
Yeah, that also sounds like a go back and do it again, go back and try again, guys.
Yes.
I don't care for that.
But we got an answer to a question that we didn't have an answer to before, so I will say in that aspect, it backfired and it's a win.
Okay. I mean, okay. You are assigning a lot more purity of heart than I would assign, I suppose. You see the good in people, Richard.
I try to rationalize things that they don't need to be rationalized. And here, this is a good time. We'll throw the case up here if you want to see the citation and go check out the opinion. It's a pretty long one. This is about 100 pages. Where does this case go from here?
Well, it will most certainly be appealed up to the Second Circuit once again, because if you're sitting out there, a non-lawyer, thinking, oh, you litigate a case and then it gets appealed to the intermediate court and then it gets appealed to the Supreme Court, you would be extraordinarily wrong. It's more like a weird game of
whack-a-mole.
Yeah, whack-a-mole is a good description for that. So we are appealing tons of little side issues up and down and up and down and up and down. That's Miss Rachel that I just busted into by accident because I have children. So we have although it's been up to the Second Circuit once already, it will go back up. However, I do anticipate, given the litigation that's already occurred in this case, that the Second Circuit will once again affirm. And this is not a Supreme Court case.
No.
Not by any stretch of the imagination. So, we would have a final decision on this within a year and a half.
Yeah, I'm hopeful.
So it only took, I don't know, what do you think it cost FPC? $500,000?
Oh, I don't even want to estimate. It could be a lot.
So, I mean, it's just a matter of 4 to 5 years and 6 figures worth of attorney's fees, right?
Yeah.
No big deal. No big deal. That's why they won.
Yeah.
That's why it wasn't a backfire.
But, and we've had this discussion before, all right, what happens when we have all the answers to the questions that haven't been resolved left by New York State Rifle and Pistol Association? Where do the gun grabbers' money go after that? We'd like to hear, actually, as someone who gives a lot of unsolicited advice to the Illuminati, I'm going to keep this one to myself. But we hope you enjoy this discussion. If you did, consider subscribing, hitting the like button, and help us fight the anti-2A algorithm by sharing this video.
And I can't believe you admitted the Illuminati was real. And please always question comments for us below. Until next time, we're the Arms Attorneys.